Welcome back. We continue day 2 of our coverage tonight of the Miller hearing for the Oxford High School shooter. We heard emotional testimony today from witnesses and the shooter's legal team trying to paint the picture that teen's parents did not address his mental health issues.
The defendant has pleaded guilty to 4 counts of first-degree murder and terrorism resulting in death. This Miller hearing is a required proceeding to determine if the teen is eligible for a mandatory life sentence without the possibility of parole.
We continue our coverage now with retired Third Circuit Judge Vonda Evans, as well as attorney Sanford Schulman, an attorney who's a leading expert on these Miller hearings here in Michigan. Thank you both for being here tonight.
Thank you.
Sanford, let's start with you. You're very familiar with Miller hearings. Why are they needed when the prosecution has the burden of proof?
Well, they're needed for the judge to decide what the sentence is going to be. And the judge has a very difficult decision to make. And what the judge has to decide is whether to sentence to mandatory life or a sentence of 25 to 40 years on the minimum. So the defense and the prosecutor have to present these factors for the judge to consider what is an appropriate sentence. The challenge for the defense is that how do you show that he's been rehabilitated? How do you show that there's any type of remorse? He's been in jail for a year. Most juvenile lifers have been in prison for decades. So when I handle those cases, you have such a significant record that you can show that he's been in church or he's been working or he's a mentor. For this defendant, you don't have any of that. So how do you humanize him? How do you make him a human? And the victim and their family certainly don't want to hear him as a human. The public, many of them don't want to hear about his troubles. And his apologies are going to be on deaf ears. So how do you make him a person? That's the judge's job, and that's a difficult one, perhaps the most difficult. Those judges who handle civil, it's about money. For those judges who handle divorces, it's about custody and parenting time. Those are important. Those are emotional. But this is on the top. This is about life in prison for a youth or a set of years. So that's what the judge is challenged with, and that's what the judge is going to have to decide.
Now, it is rare for a Miller hearing to result in that mandatory sentence without any chance at parole, correct?
First, the prosecutor has to ask for it. That's how it starts. In this case, the Oakland County prosecutor has asked for that hearing. So the judge has to now decide it. But the prosecutor, in some situations, don't have to ask for that Miller hearing, and the judge can then set a sentence, usually between 25 and 40 years. So it starts with the government deciding if this is an appropriate case. And again, the stakes are so high. Mandatory life. He gets no more Miller hearings. So in 20 or 30 years, if his record is impeccable, he serves a mandatory life and dies in prison. That's why the stakes are high, and that's why the record is limited and the judge's challenges are very high.
Judge Evans, have you heard anything today or even yesterday that would suggest this may be that rare case that results in that high stakes decision?
You got to listen to everything. And you know, the uniqueness of this matter is that Attorney Schulman actually did a Miller hearing. And so he was able to contemplate offensively, defensively with the judge. So I think that I'm going to defer to him because he knows all of the players and he knows what to anticipate. And I think that what we're trying to do at this point is look into the future. And I think that Attorney Schulman has had a glimpse into it, at least in another case.
Well, how difficult is that? I mean, we're hearing of the mental issues, the struggles he had, the text messages, a dozen or more text messages read in court, asking his parents for help, texting a friend, "I need help." And then we see what's going on, or we're hearing what's going on in prison, where he's hearing thoughts and things in his head.
Jail.
Excuse me, jail. How do we know? How do we know? It's impossible to know, right? That he will be rehabilitated in 60 or 80 years.
Right. So people who've done Miller hearings know that the key to success is the rehabilitation factor. It's the 5th factor, but I think it's the most important. How do you show someone's redeemable? You know, he's sitting in the courtroom, he's got no real history of that. How do you show that he's remorseful? He's going to stand up and say, "I'm sorry"? That's what's going to do it? Of course not. What's going to show that he's remorseful is a history of showing that he's rehabilitated. It's going to take decades. But he won't have the chance in decades if the judge gives him mandatory life. And I know we so want punishment. That is part of sentencing. But there is a part of us and the process that says, can you rehabilitate? Is he incorrigible? Now, the Supreme Court said that's not necessarily the factor, but is there any redeeming factors that make this human being something that he has a shot, a possibility of something less than his remainder of his life in jail or prison? And the prison will not be easy for him, not after this. But in years and years and years go by, as I meet the Miller defendants, we call them, the defendants facing resentencing, they're absolutely completely different from what they were when they were 16 and 15. They don't have a molecule or DNA like they were when they were 15. And I'm sure if we went into your past and you think about ourselves as 15-year-olds and 16-year-olds, we did things crazy, stupid, irrational. That's what kids do. That's why the Supreme Court said that youth have not developed. Their brains haven't developed. And I know there's so much emotion. We don't want to hear all this lawyer talk about the defendant. We're talking today about all the things that pull at our heartstring. And now the defense has to talk about the defendant. That's difficult. Humanize him, bring out who he is, to let the judge know that in 30 or 40 years, that person is going to be so different. And the ones I sit across from are mentors. They're clergy. They're helping people. They're really great humans.
And the case that Attorney Schulman was successful for was a police killing. And at the time, everybody was up in arms. This defendant killed a police officer. But because of what he was able to do while incarcerated, the judge said, I'm going to let him go.
It seems like such a philosophical question. I mean, one of the doctors on the stand today said he's never encountered anyone who you could definitively say there's no chance that this person will ever be redeemed down the line. How do you, as an attorney involved in these cases, get around that abstract nature in the legal system?
Yeah, that is the challenge. How do you get beyond the facts in the case that are the atrocities, and how do you make this person humanized in terms of what is favorable, what's their positive characteristics, and also what kind of trauma they've gone through. And again, the judge is detached. The judge is supposed to be unbiased, but he's human, and we're all human, and we are pulled by the atrocity and the emotional factor, but the court is required to also look at him and his challenges and the emotional factors that he has been challenged with and make that decision. And that's why it's so difficult. Emotions on both sides.
Vonda, as a former judge, hearing everything you heard today from the defense and hearing everything we heard yesterday from the prosecution, do you feel like this is leaning one way or another for
Absolutely
the judge?
not. Listen, I'm not going to call it till the fat lady sings. Can't say that. I don't think, the skinny lady sings. I don't know what's appropriate. I'm not going to make a judgment until I've heard everything.
But what is your feeling?
You know what? Feelings come, feelings go. I don't, as a judge, I'm detached. I don't rely on feelings. They're just that, feelings. I want to know, show me the facts. I'm from Missouri. Show me the facts. And we need to look at it. And I won't really render a decision. However, I will agree with Attorney Schulman. The judge has his work cut out for him.
Yeah. All right. Retired Third Circuit Judge Vonda Evans and defense attorney Sanford Schulman, thank you both for sharing your insight with us tonight. We do appreciate it.
Thank you.
And we will have continuing coverage throughout the evening tonight with more analysis of the hearing. And our Gavel to Gavel stream continues Tuesday morning at 8:30. You can watch all day long on CBSNewsDetroit.com.